And your daughter wants to go there for education. Environmental science.
Will the Senate please come to order? Our devotional exercises will be conducted by the Reverend Mark Orton of Charles P. Scott Center for Spiritual and Religious Life of Middlebury College. Welcome.
Good morning. As was said, my name is Mark Orton, and I'm the Dean of Spiritual and Religious Life at Middlebury College. This weekend at Middlebury, we will be celebrating the commencement of the class of 2025. And on the day before that, I'll be giving the address at our annual baccalaureate service. As part of that service, we ask 6 different students to read words on wisdom from 5 different religious traditions, along with 1 secular reading also on wisdom. Each of the readings is recited first in its original language, Hebrew, Sanskrit, Greek, Arabic, and Chinese, and then translated into English. It is a beautiful reminder of the varieties of expressions over the millennia of humankind, of mature human knowledge and divine understanding for living together peaceably. I offer just a few brief snippets of those as you begin your deliberations and decisions on behalf of all of us in Vermont. Whoever is given wisdom has truly been given much good, reads the Quran, but only those with insight bear this in mind. The Lord founded the earth by wisdom, say the Hebrew Proverbs. Who among you are wise and understanding, asks the book of James in the Christian New Testament. By their good manner of life, let them demonstrate their deeds in wisdom's meekness. And finally, from the Bhagavad Gita, in the Hindu tradition, we read, in this world there is no purifier like wisdom. With wisdom as the highest goal, controlling the senses, and filled with trust, one reaches wisdom. There, having attained it, one goes quickly to the highest place. May this chamber be for us today and all days a place of deep deliberation, rich with compassionate contemplations, devoid of petty considerations, and appealing to the wisdom of our ancestors, trusting the truth of our own experiences, and seeking overall the well-being of our neighbors and of our enemies. May it be so. Amen.
Are there any announcements? Seeing none, we have a couple bills for reference. We will start with H 479, which is referred to finance under Rule 31. 2 of them. We now have H 319 and H 472, which will be referred to appropriations under Rule 31. Orders of the day. We are skipping H50 for now, which brings us to H105. We have on the calendar for action H105, which was passed by the House on January 20, 2025. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the Senate propose to the House that the bill be amended as it appears in today's calendar, and that with such proposal of amendment, the bill ought to pass. Listen to the second reading of the bill.
H105, an act relating to expanding the Youth Substance Awareness Safety Program.
Recognize the Senator from Windham District, Senator Hashim, for the report of the Committee on Judiciary.
Thank you, Mr. President. This is located on page 2090 of today's calendar and with an amendment on page 2099, which I will present after this. So H105 is a bill that is intended to expand the youth substance safety awareness program. There are several substantive changes in this bill that are meant to streamline the judicial process and make sure that youth are getting access to resources that make sense when it comes to underage substance use. And one thing I do want to highlight at the beginning is that none of these changes necessarily prohibit criminal prosecution when the elements of a crime exist. Oftentimes in these situations, there are two tracks, the civil track and the criminal track. This bill focuses on the civil track. Before I get into the substance of the bill, I also want to describe the function of the Youth Substance Awareness Safety Program, which I'll refer to as YSAS moving forward. YSAS provides an alternative to the civil court process for youth who violate Vermont's underage alcohol and cannabis laws. YSAS is an educational and rehabilitative program that helps young people understand the impact on themselves and others of using these substances and to lower the risk for future use, while connecting those identified as high risk to professional substance use clinicians. So in other words, instead of just paying a fine in civil court, this is a path that actually takes steps to remedy the underlying issue. Failing to complete the program does also carry its own consequences. So Section 1 of the bill amends 7 VSA 656 by adding the underage impaired driving provisions of 23 VSA 1216 into new proposed subdivisions 656B1E and B3. This section adds the civil violations for cannabis possession for those under 16 years of age into subdivisions B1D and B2. It also adds that those who are 12 but not yet 21 years of age and engage in impaired driving with a blood alcohol concentration of 0.02 or more and fails to complete YSAS will be liable for a civil violation handled by the Judicial Bureau. This change aligns these violations with the civil treatment afforded for underage violations related to procurement, possession, and consumption of alcohol. While all violators of this section are required to enroll in YSAS, the difference is that impaired driver violators will also have their license suspended under subdivision 656B3 for a period of 90 or 145 days in accordance with subdivision B3B. A person's license will be automatically reinstated after completing the suspension. Similar to violators of subdivision B2, if impaired drivers fail to complete the YSAS program, their case goes before the Judicial Bureau to be treated as a civil violation with potential penalties including fines of $300 and $600. In addition to enhanced license suspensions of 180 days or 1 year in accordance with subdivision B3A. In this situation, a person has to go through the standard reinstatement procedure once the license suspension is served as described in subdivision B3C. Currently, a person cannot be cited for more than one violation of section 656. However, we did add a requirement that the citation will indicate the presence of multiple substance for the purpose of intake and conversion programming purposes. This is so that the intake service will have a more nuanced understanding of the participants' substance use issues, such as whether it was a one-off incident at a party or if they are regularly dealing with a range of serious substance use. New subsection D proposes the suspension notice procedure. There will be a technical amendment about this. This requires a law enforcement officer to issue a notice of suspension that includes information concerning the suspension's effective date, duration, and explanation of suspension consequences, methods to acquire a restricted driver's license, and the projected date of license reinstatement. Amendments to subsection I outlines confidentiality and public records exemptions, considerations that permit the reporting of license violations to law enforcement and to insurance companies. The addition of subsection J requires that the Attorney General reports to the standing committees of jurisdiction concerning the number of persons referred to YSAS, their ages, the number of successful completions, the number of failures, and the number of people who serve suspensions imposed by the Judicial Bureau after they fail YSAS. Section 2 of the bill creates a specific requirement for the first report from the Attorney General, which mandates that the Attorney General's Office, Vermont's Statistical Analysis Center, and others propose outcome measures to assess the effectiveness of any suspension imposed for impaired driver violations in YSAS under 7 VSA 656. Sections 3 and 4 repeal Title 7 VSA 656A, 23 VSA 1216, and a reference to section 1216 in another statute, as well as Title 18 VSA 4230B and 4230J, since they are being eliminated or modified and rolled into 7 VSA 656. Lastly, Section 5 of the bill states that it goes into effect July 1st, 2025. We heard from Legislative Counsel, the Youth Restorative Programs Manager and Coordinator from the Burlington Community Justice Center, the State Court Administrator from the Vermont Judiciary, the Director of Court Diversion and Pretrial Services, the Vermont Department of State's Attorneys and Sheriffs, the Chief Juvenile Defender from the Defender General's Office, the Executive Director of the Washington County Diversion Program, and the Deputy Commissioner of the Department of Motor Vehicles. The vote was 302. We had some members out that day, but 302, and I ask for the Senate support.
I understand the senator from Wyndham has an amendment. I recognize Senator Hashim for the report on the amendment.
Thank you. The amendment is located on page 2099. Yes, 2099. So very soon after we voted out H105, we received several additional suggestions from the Vermont Judiciary. Those suggestions have been incorporated into this amendment, which the Senate Judiciary Committee found favorable by a vote of 401. And I'll just walk through these real quick. The first instance fixes a miscited cross-reference to the definition in 7 VSA 656A. The second instance of amendment, and just to add some additional information, that has to do with the definition of what a public highway is. The second instance of amendment clarifies that it's actually the Commissioner of Motor Vehicles who is the official imposing the automatic suspension of a person's license. And this is consistent with the rest of the statute. The third instance of amendment adds a requirement that the person's notice of suspension form includes information about the person's right to have an automatic suspension reviewed under Rule 75 of the Vermont Rules of Civil Procedure. The fourth instance of amendment adds a new subdivision B to 656H5. This addition provides that a person has the ability to seek review of the imposition of an automatic suspension in court. And this is the same type of review that a person already has under this provision of law to have a decision of the diversion program reviewed. And I would ask for the Senate support of this amendment.
The senator from Wyndham, Senator Hashim, moves to amend the report of the Committee on Judiciary. I think I got that right. The question is, shall the Senate approve the amendment as reported by Senator Hashim? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it and the motion carries. The question now is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary as amended? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you have proposed to the House to amend the bill as proposed by the Committee on Judiciary as amended. The question now is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you have ordered third reading of H105. We now have S125. It was passed by the House with proposal of amendment. The question is, shall the Senate concur in the House proposal of amendment? Senator from Chittenden.
Thank you, Mr. President. In summary, we passed over this bill yesterday so that our committee could do some more due diligence on the changes, but recognize that the House and the committees of jurisdiction did take extensive testimony. We appreciate their good work and voted 5-0-0 to ask the Senate to concur with the House proposal of amendment today. I'll go very quickly through the changes. This left our chamber a small but meaningful bill in terms of the impact that it will have on collective bargaining rights. We had included 4 sections on workers' compensation at the beginning that people can find on page 2100 of the calendar. You'll see that those sections were deleted. We passed those separately in S117, basically because of how the House manages its jurisdictional questions. That went to a different committee, and that has moved forward separately. The next 2 sections of the bill have to do with JELRA, the Judiciary Employee Labor Relations Act. This now deletes the exclusion of judicial supervisors from the right to seek a collective bargaining unit or join an existing collective bargaining unit. That does not mean that they are automatically part of a union, but they now have the right to go before the Vermont Labor Relations Board and seek some form of collective bargaining and organization. We also, in this chamber, passed a provision that allows for a change in the decertification of a union vote threshold in SELRA, the State Employee Labor Relations Act, to go from 30% to 50% plus 1 to trigger a ballot to potentially form a new union or have a new representative under which they would organize. We likened this on the floor to having to go to your constituents and potentially be called up for re-election or recall when 30% of your constituents are unhappy. That would be very difficult circumstances for us to lead and govern and convene. And our unions, our Vermont State Employees Association was asking for the same thing for SELRA. What the House did was then create sections 5C through H, which we accepted as a very friendly and complimentary amendment that changes the same threshold for all of the other existing union entities in the state. So now that we have allowed more in the judiciary to organize, this increases that threshold for the Judiciary Employees Labor Relations Act, then the Labor Relations Act for teachers and administrators, the State Labor Relations Act, which helps with other private and quasi-public entities, the Municipal Employee Relations Act, the Independent Direct Support Providers Labor Relations Act, which is essentially home care workers or domestic workers, and the Early Care and Education Providers Labor Relations Act. They now all have a 50% plus 1 threshold in order to decertify their union and start over with the organizing process under a different union. Finally, the House looked at our proposal to require employers and subcontractors of the state above $100,000 of state dollars to submit their certified payroll weekly to the Department of Labor and the agency that's overseeing their project. The House deleted that section, and we felt that it was prudent to concur at this time and perhaps revisit that issue at a later date. Given all of that, the effective date is July 1st, 2025, and the bill will now be an act relating to collective bargaining, taking out the workers' compensation piece since that passed in another bill. Thank you, Mr. President. Again, our vote was 5-0-0, and we ask the chamber to concur.
The question is, shall the Senate concur in the House proposal of amendment? Are you ready for the question? If so, all in favor, say aye. Aye. All opposed, nay. The ayes have it, and we have concurred in the House proposal of amendment on S-125. We now have H-238 for third reading. Are there any amendments prior to third reading? Listen to the third reading.
H-238, An act relating to the phase-out of consumer products containing added perfluoroalkyl and polyfluoroalkyl substances.
The question is, shall the bill pass in concurrence with proposal of amendment? Are you ready for the question? If so, all in favor, say aye. Aye. All opposed, nay. Ayes have it, and we've passed H 238. We now have H 504 for third reading. Are there any amendments prior to third reading? Seeing none, listen to the third reading.
H 504, an act relating to approval of amendments to the Charter of the City of Rutland.
The question is, shall the bill pass in concurrence? Are you ready for the question? If so, all in favor, say aye. Aye. All opposed, nay. The ayes have it, and we've passed H 504. We now have on the calendar for action H 106, which was passed by the House January 28th of 2025. It was referred to the Committee on Economic Development, which reports it has considered the bill and recommends that the Senate propose to the House that the bill be amended as it appears in today's calendar, and that with such proposal of amendment, it ought to pass. Listen to the second reading of the bill.
H 106, an act relating to selling property within a FEMA-mapped flood hazard area.
I recognize the senator from Rutland District, Senator Weeks, for the report of the Committee on Economic Development.
Thank you, Mr. President. On behalf of my colleagues in the Economic Development and Housing Committee, I bring you H 106. This is an act relating to real estate in a FEMA flooded map hazard area. You're invited to follow along in today's Senate calendar on page 2107. In the military briefing style, which is completely different from the presentations I've observed in the State House, in the service we start with the BLUF. And this is an acronym standing for the bottom line up front. So the BLUF, 500 in the Economic Development Committee, and 1001 in the House Committee on General Housing. Now everybody can relax. So the intent of H 106 is for the General Assembly to ensure that a buyer of real estate is aware of flooding risks associated with the property. So maps and charts are enormously important, were enormously important in my career. I use maps to keep ships and gunboats out of shoal water. So as you can imagine, a billion-dollar warship and a coral reef are not compatible. So in my world, we use charts that were at times printed 100 years ago. At other times were electronically updated by the hour. And I mention this only because, I mention these old maps only because this is an issue, this is a criticism with FEMA maps. So FEMA flood zone maps reflect the uncomfortable reality that we have homes and businesses built in floodplains. Okay? So FEMA flood zone maps are online, and they're often posted in town halls and are routinely updated with vetted information, but can be the subject of criticism. This bill does not assure that the FEMA maps are 100% accurate or that they're completely up to date. But these maps do provide an excellent awareness of the level of risk of any plot of land. So via this legislation, property sellers must provide information in their property disclosure statement, right along with the background of whether a home or a business contains asbestos or underground fuel tanks, etc. So already in legislation is the fact that a seller must disclose that the property experienced flooding or flood damage during their ownership. This bill modifies the current requirement to disclose whether the seller maintains flood insurance, meaning that they have bought flood insurance. So they have to disclose that according to this new legislation. And they must also disclose if they're required to have federal or state flood insurance, required by law to have federal or state flood insurance. So there's a difference between actually having it and being required to have it. So the addition in this bill is also for the seller to provide a physical copy or an electronic copy or a digital link of a relevant FEMA flood map. The effective date of the legislation is September 1, 2025, to allow realtors to update their forms to include the FEMA flood zone disclosure section. The committee took testimony from Representative Dulgen from Caledonia, Essex, the House Bill reporter, the president of the Vermont Bankers Association, the Vermont Bar Association Property Law Section, the Director of Public Policy at Vermont Association of Realtors, Cameron Wood, our Office of Legislative Counsel. So back to the bluff. The committee voted 5-0-0. The Economic Development Committee welcomes the full chamber to support 5106, and I thank the President.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Economic Development? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you have proposed to the House to amend the bill as proposed by the Committee on Economic Development. The question now is, shall the bill be read a third time? Are you ready for that question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you've ordered third reading of H 106. We are passing over H 545, which moves us on to JRH 5, Joint Resolution, authorizing limited remote joint committee voting through the remainder of calendar year 2025, offered by Representative Kowinski and others. It was read and adopted by the House May 20th of 2025. Listen to the reading of the resolution. The question is, this resolution has been read already and is set forth in yesterday's journal, which is before you. Shall the Senate adopt the joint House resolution in concurrence? Senator from Chittenden.
Thank you, Mr. President. Just an explanatory note about this. You know that we updated our rules, our Senate rules, at the beginning of this session to continue our use of remote voting in committees. The House has slightly different rules that they abide by, but when we meet jointly, we have generally adopted the House's rules for remote voting. So that understanding needs to be re-upped in order for us to meet remotely in joint committees once we adjourn. So this is moving us between our adjournment and January with the same rules that we've been living under. We haven't heard any problems with those rules, and so we voted to bring this to the floor. Thank you, Mr. President.
You're welcome. Senator from Windsor.
Thank you, Mr. President. Would the pro tem be kind enough just to remind us what those rules are?
Senator from Chittenden.
It allows attendance and voting remotely. There does need to be a physical presence in the State House, a meeting being conducted in the State House.
Thank you.
Is everyone ready for the question? The question is, shall the Senate adopt the joint House resolution in concurrence? All in favor say aye. Aye. All opposed, nay. The ayes have it, and the Senate has adopted the joint House resolution in concurrence. That completes the orders of the day. Are there any announcements? Senator from Chittenden.
Thank you, Mr. President. As you know, morning committees have been shut down. Nevertheless, I'm asking Senate Health and Welfare to meet tomorrow morning at 9 o'clock and also on Friday morning at 9 o'clock so that we can look at bills coming back from the other body and also the resolution that we are working on. Thank you, Mr. President.
Senator from Windsor.
Thank you, Mr. President. The Climate Solutions Caucus invites all of you to that free food gathering I mentioned yesterday, tonight at 18 Baldwin Street from 5 to 7 p.m. All are welcome, informal. Please join if you would like to.
Senator from Bennington.
Mr. President, the Education Committee will meet at 2. I have a second announcement, if that's okay. The Vermont Habitat for Humanity affiliates would like to invite senators to join them on the State House lawn today. We can hear it out there. For lunch, a group photo, and to see the panels being assembled for a 3-bedroom, single-family home that will be built in Manchester. I actually don't know how they're getting them back to Manchester, but anyway, through their low-income affordable homeownership program. So they're asking you to come by, sign a stud, put in a few screws, take a picture, and congratulate the new homeowners. So at noon out on the lawn. Habitat for Humanity.
Are there further announcements? Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1 o'clock.
Senator from Washington.
Thank you, Mr. President. Senate Appropriations will meet at 11:30.
Senator from Rutland.
Thank you, Mr. President. Government Operations at 1:30.
I was wondering if we were going to have a trifecta of senators from Washington, but one declined.
Oh.
Are there any further announcements? Senator from Chittenden.
Thank you, Mr. President. Pending any further announcements, I would move that the Senate stand in adjournment until 10 a.m. Thursday, May 22nd.
The senator from Chittenden has moved that the Senate stand in adjournment until 10 a.m. Thursday, May 22nd, 2025. Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it. We'll stand in adjournment until 10 a.m. Thursday, May 22nd, 2025.